Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
In a week where I've certainly been counting my blessings and obtaining a sense of perspective, and where Dominic Raab has pledged to quit if found guilty of allegations of bullying, the machinery of local government continues to turn. Dennis, a planning item first, I think.
Indeed it is. James Gowdy KC is one of our most popular and entertaining speakers at LLG conferencing, and his attention and ours were drawn to a recent planning case concerning planning officers' reports, and more specifically their significance at committee and whether they can be the basis of a judicial review. Here's his summary. The legal principles relating to the reports of planning officers are already fairly well settled. Nonetheless, challenges based on such reports continue to proliferate, and judges find it necessary to restate those principles. In the Crown on the application of Armstrong against Ashford Borough Council, Mr. Justice Bourne summarised the principles as follows. 1. The weight to be given to material considerations is for decision makers to decide. 2. Reports to planning committees should be both concise and focused. 3. The assessment of how much and what information to include is for the expert judgment of planning officers. 4. Judicial review will not make headway on the basis of a defective report unless the overall effect of the report significantly misleads the committee about material matters which thereafter are left uncorrected at the meeting of the planning committee. And 5. Courts should make a fair reading of each report as a whole. And finally, 6. Reports should be read bearing in mind that they are addressed to a knowledgeable readership, and in challenges to the decisions of democratically elected and experienced members of planning committees, courts should proceed with prudence and caution. Planning officers and governance specialists will want to look at this case in some detail, together with other related commentary also available in the bulletin.
Now, the world's biggest trial of a 4-day working week has been hailed a success, with most of the companies involved saying they would continue offering a shorter week. A total of 61 companies across several sectors in the UK were involved in the pilot, which ran for 6 months from June last year. Research carried out by the University of Cambridge and Boston College found that the number of sick days taken by the 2,900 staff in the trial fell by about 2/3, and further that 39% of employees said that they were less stressed. However, the Law Society Gazette reports that no law firms were willing to take part in the pilot, and that Programme Director of 4-Day Week Global, Alex Sujong Kim Pang, explains this as follows. My own experience, he says, from working with companies is that cultural norms in the legal profession and the habits created by billable hours make it especially challenging to move to a 4-day week, but there is interest in it. He went on to say, I think there's a widespread recognition that current legal practice burns people out unnecessarily, shortens the careers of people the profession would benefit from having, and makes for worse law, and needs to change. Figuring out how to redesign legal practice and managing the transition to more sustainable careers and practice is the challenge. Well, certainly working from home and remote provision was a rarity pre-COVID and was probably considered unworkable by many. However, necessity demonstrated that not to be the case. And here we all are in shining hybrid glory. So perhaps a focused creative approach will eventually see a 4-day week as the cultural norm across all sectors. Eventually. Dennis.
Helen, I want to talk next about strip clubs. Here's the story. To be precise, I want to talk about the licensing of SEVs, what are better known to licensing lawyers as sexual entertainment venues. 2 cases came before the courts very recently on matters of licensing policy. The first concerns Edinburgh City Council and its proposals to establish a blanket ban on the operation of strip clubs in the city. The second case concerns Bournemouth, Christchurch and Poole Council, who wanted to achieve the opposite objective by adopting an unlimited policy for strip clubs to operate in its area. Let's turn first to the Edinburgh case. A Scottish court has found that Edinburgh City Council's decision to implement a nil cap or blanket ban on strip clubs was unlawful, following a legal challenge brought by a sex workers' union. The claimant, the Union of Sex Workers, said that it hoped that the ruling will discourage local authorities across the UK from imposing bans on sexual entertainment venues. In the Scottish Court of Session last week, Lord Richardson accepted two grounds of argument brought by the union. The first was a claim that the local authority had misdirected itself in law by taking into account a number of irrelevant factors. The second successful claim alleged that the council's decision constituted a disproportionate interference with the rights of its union members in terms of Article 8 of the European Convention of Human Rights. Now, it is this particular finding that will interest licensing lawyers across the UK and in local government in particular. In the Bournemouth case, a High Court judge quashed a local authority's decision to adopt a policy of having no cap on the number of sexual entertainment venue licenses that may be granted in its area. In this case, the policy was quashed on two grounds also. First, that consultation exercises previously undertaken by the council were not conscientiously taken into account before deciding upon the policy. And secondly, the judge was not satisfied that the public sector equality duty had been properly considered and rigorously applied. Now, licensing lawyers and governance specialists will want to examine these cases closely when licensing policies come under review in their own authorities.
Moving on to an interesting working paper from the Hansard Committee entitled Proposals for a New System for Delegated Legislation following preliminary proposals arising from the Delegated Legislation Review, which the Hansard Society has been conducting since November 2021, with financial support, it should be added, from the Legal Education Foundation. The report states that legislative scrutiny is one of Parliament's core functions, but the delegated legislation system is no longer fit for purpose, it found. It's now a growing source of political frustration across the political spectrum. The report states that the system undermines the constitutional balance between the executive and the legislature, damages the reputation of Parliament, and squanders one of the most valuable commodities in politics: MPs and ministers' time, particularly that spent in pointless delegated legislation committees in the Commons. Excellent scrutiny of statutory instruments, it says, is conducted in the House of Lords, but parliamentarians' inability to amend an instrument blunts the value and impact of this work. Civil servants also waste time and resources navigating what has become an increasingly complex system. But ultimately, the price of poorly conceived, poorly drafted, and poorly scrutinised legislation is paid by citizens across the country who are subject to its detrimental effects. Unless the problems with the system are addressed, public acceptance of the democratic legitimacy of delegated legislation will come under increasing strain. Now, the working paper sets out 13 draft proposals to reform the system. Frankly, it's an eye-opening account, and given that we are facing the EU revocation bill, of huge interest. Dennis, what's your last item today?
Well, allow me to explain. We've all been there. A frustrating email is in front of you on your computer screen and cannot be avoided. You start to obsess. It's an infuriating email from someone who's been driving you mad for weeks. However, an inappropriate reply from you might land you in a lot of trouble, and here's why. It has been reported in the Law Society Gazette that a solicitor who told another lawyer, "You are only one step closer to your grave," has been struck off for serious misconduct. The article lists the circumstances, but the Solicitors' Disciplinary Tribunal is clear about how solicitors ought to behave. In a judgment published last week, the tribunal said, even in the context of hostile litigation, members of the public would expect solicitors to be robust but temperate in the language they used when communicating with the other side. And that expectation was even higher when those communications were with the lay client. The solicitor involved had also failed to cooperate with the SRA during its investigation, deliberately withheld information, and misled the SRA in a number of material matters. Accordingly, the tribunal ordered a strike-off. He was also ordered to pay costs of nearly £42,000. Now, before leaving this item, can I offer some brief advice on how best to avoid yielding to the temptations that sometimes grip you when you're annoyed or angry and you need to express yourself in a response to someone who has really got to you? 1. Remember that famous line from the Godfather film, "Don't ever get angry, it disturbs your judgment." That says everything really, doesn't it? 2. When drafting an email or other form of correspondence, be conscious at all times that what you say could be subject to external scrutiny by a judge or tribunal or by an ombudsman or similar. 3. At all times, make all efforts to appear to be reasonable, even though you and I know that you're not. And finally, 4, demonstrate where necessary that much prized skill that lawyers are supposed to be good at. Be persuasive when circumstances require. Helen.
Well, in other news, concern is growing following a slow uptake in voter ID applications in the form of voter authority certificates needed by the 2 million individuals in order to vote who are currently without photographic ID. Reported in the BBC and many other places, just 21,300 individuals have applied since the scheme opened last month. Now, quite whether this problem is as concerning as is being presented does remain to be seen, but no doubt the brunt, if it comes, as always, will fall on those officers inside the church halls and community centres on election day. Before I wrap up, I just want to mention that LLG are currently in its own elections for a number of positions, and those eligible to vote will have received an email. So please do make sure you exercise your democratic vote. No photographic ID is required. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 7, available now on the LLG website. So it's goodbye from me.
And the same from me too.
Thank you for listening. Have a good week, everyone.